Good afternoon, everyone. I'm Dave Pelton from Vertex. I'm the product line leader for transaction tax. I've been at Vertex for about 11 years now, and as you probably are aware, this is a big decision for the sales tax environment in the sales tax world. So today we are going to try to help you understand some of the implications. I'm going to start by introducing our three panelists. Mike Bernard is the Chief Tax Officer for Transaction Tax for Vertex. He's an executive-level tax attorney and provides insight and thought leadership around tax department operations, U.S. indirect tax, tax risk management, and tax policy, as well as emerging tax trends. Nancy Manzano is a director in the Chief Tax Office at Vertex, responsible for insight and thought leadership regarding in-house corporate tax department operations and tax solutions. And Rick Heller is a managing director in the technology, media, and telecommunications practice of Deloitte Tax. Rick focuses his national practice on advising telecommunications and communications-related service providers, including cloud computing and electronic commerce vendors. Welcome to the panelists. So for today's webcast, we're going to assume that you have a basic understanding of the case. We'll have a very brief synopsis of it, but we're not going to go into a lot of detail about the ruling, about the constitutional arguments or the precedents, because we're really going to want to focus our time on the implications of the decision, because they're big implications for a number of companies, both in the U.S. and internationally. So our first series of questions is going to be centered around what the response is from the states. What do we expect the response to be? What are we hearing already? So I'm going to direct my first question to Nancy Manzano. What states have actually had some activity? How do you see the states reacting? And maybe you can talk a little bit about, buckets of states and different thresholds and whatnot that you're seeing.
Great. Thanks, David. So since the decision was announced, we have heard from many of the states that already have some form of economic nexus statutes already on their books. And that's kind of the first bucket that I would say we have of states. And among those states, we're seeing, kind of different flavors of the South Dakota statute. We're seeing varying thresholds or that small seller exception. For example, instead of the $100,000 and 200 transaction threshold that's present in the South Dakota legislation, states like Massachusetts have a slightly different threshold, $500,000 and 100 transactions, and it's an and test for Massachusetts as opposed to an or test. We're also seeing nuances in the measurement period for the thresholds. It could be the previous calendar year. It could be a rolling 12 months. And we're also seeing some differences in effective dates. There are some states that have come out in their announcements and said that they're going to start requiring collection and remittance activities beginning in July of this year, in October of this year, and we even have some that are going backwards into, say, January of 2018 in the instance of Hawaii, for example. So that's kind of that first bucket of states that we're definitely hearing from. I think just about every day we're seeing another announcement coming out at this point now that we're, in the kind of 3-week post time frame. So another bucket of states are those states that also have economic nexus statutes but may have some kind of impediment to enforcing those statutes based upon some sort of injunction or other enforcement impediment that they have in the state through, say, it could be an injunction on enforcement because of the outcome of the Wayfair case or waiting for the outcome of a case that's actually in that state. So that's another bucket that we're hearing from. And another bucket of states that we're hearing from are those that have simply, announced at this point that they are reviewing the court's opinion to determine what the impact is going to be. In other words, we're not going to do anything yet. We want to take some time to understand all of the implications before we make any specific announcements.
And Nancy, it's Rick Heller. I would add to that, there's the last bucket of states that don't have sales taxes at all, and New Hampshire has come out recently with an interesting proposal that the governor is pushing with the legislature to put in a statutory process where if another state wants to come in and audit a New Hampshire-based company that's selling remotely, that they have to register with the Department of Justice in New Hampshire, and the Department of Justice is going to apply the tests that the Supreme Court talked about regarding small business exceptions and lack of retroactivity and things like that, and to make sure that it's a legitimate foreign state statute that should be imposed on their own state's businesses. So New Hampshire's coming out with an anti-Wayfair proposal.
Okay, thanks, Rick.
Yeah, that is interesting because the Supreme Court was real specific about retroactivity, and it sounds like some states like Hawaii are really not looking at changing that and aligning their regulations with that. So I'm going to move us along here. I'm wondering, what types of incentives or amnesty programs might we see from the states to try to entice companies to act quickly to comply, by collecting, remitting, and calculating taxes? I'm going to direct this question at Mike.
Okay, Dave, thanks, and good to be with all of you on the webcast today. I do want to just back up just for a second on the thresholds, though. I would point you to, many of you are probably wondering how states can have different thresholds, both from a sales perspective and also a transaction perspective. I think if I could point you to anything, I would go and take a look at the Tax Foundation brief, the amicus brief that was filed. You can find that on the Supreme Court website, where they did some analysis, and essentially what they did was they took the population of South Dakota relative to the population of New York and saw that the exemption that was being granted in South Dakota was kind of rationally related, at least to the limited 10% of the bottom of the market selling into South Dakota. So in other words, that if you were a remote seller selling into there and your activity was, say, 10% or below of all activity in South Dakota, then you were that's where the exemptions were drawn. I think some of the folks on the call, you can ask and say, well, is that something that I can challenge? And in a court, I don't think it is. I think it's probably fairly, that's how they were drawing the line. I think that's what the Supreme Court actually said on page 23 of their opinion. And then also on the retroactivity, and I know Rick would have some thoughts on this, but on the retroactivity piece of it, one of the reasons that Quill was not upheld was because there was a retroactivity piece in there, and South Dakota did not have that. So I think retroactivity is going to, and there I would point you to probably one of the better amicus briefs that was filed at the Supreme Court was the Tax Executive Institute brief, so the TEI brief. It has some very good policy arguments to it. It has some very good legal arguments to it. So if you want to read up on either one of those on thresholds or you want to read up on retroactivity, I would point you to those two amicus briefs. They're still up on the Supreme Court website, and you can access those easily. In terms of incentives or amnesty programs, I think one of the things that you kind of have to think about just top of mind is that if there's going to be any kind of deferred enforcement on this or any kind of amnesty, it's going to be tough for a remote seller just from a political standpoint to be able to go into a state and ask for relief because, I mean, think about it. You're talking about somebody going in who is a small seller, who is not a voter, and so probably has little or no influence with the Department of Revenue or with legislators there. Now, having said that, I know at one point the MTC was working on some provisions to, if they couldn't get on board at the time that states were asking them to get on board to file, that there was going to be VDAs or voluntary disclosure agreements where they could file later on or make some payment into the states. We haven't seen a whole lot of activity yet on that, but I would say to you, if you're not going to be prepared to file on the date that the states are telling you that they should be filed, you probably should try and make some estimate of what you're going to owe and at least try and start to collect in some manner. Rick, I don't know if you've got some other thoughts around that.
Yeah, I mean, there was an MTC call on Friday, I believe, last week, and, you know, obviously Wayfair was a topic on that call. So the MTC is trying to organize around putting together a Wayfair response working group for those states that are pretty active in MTC. And also, we do see legislation in a number of states. There's already a Wayfair bill in the works in the state of New Jersey. There's an amnesty bill in the works in the state of New Jersey. So I think you're going to see more efforts to give taxpayers an opportunity to try and register and avoid retroactive penalties in a number of states. In a number of other states like Massachusetts and Hawaii, you know, they've already come out with announcements that they're going retroactive to some point in time. And as was discussed, we're waiting for announcements from some other states. So, I mean, you know, sales tax collectors and remitters, you know, should be looking at the situation and trying to track it in states that are material to them from a sales perspective. And, you know, if you can start collecting and remitting in these states to reduce your potential uncollected liability, it's a good idea to come online as soon as you can in a number of these states that are becoming active each month.
Well, that's great. Great advice. I'm gonna move us in a slightly different direction. So, a big part of the dissent in the decision was around the thinking that, well, this is Congress's job to determine nexus for remote sellers. I think, you know, four out of the dissenting decisions included that. And I'm wondering, I'm going to point this to Rick. Do we think that Congress is going to act at all? Do we think you know, some legislation will get pushed through?
Well, trying to predict what Congress will and won't do is a tough game, but you know, there is some impetus with bills that have been introduced in the past. There's been a number of marketplace fairness or streamlined sales tax bills that have been introduced over time that have made it through one house or the other. You know, there's a number of bills that are introduced right now sitting in Congress that are either you know, bills that would provide some guidelines for enacting the Wayfair case, or, you know, make standard limits across the states, or require some type of simplification similar to the streamlined sales tax project across the states. So there's a number of pro-business bills that could be in there. The question is, how much lobbying will the business community do to get these bills passed? And so the response that we've seen from industry has been mixed. A number of the big online sellers have put out announcements that they're going to acquiesce and, quote, voluntarily register in a number of states. You know, the other spectrum of sellers are the ones that are saying they want to fight it. They're encouraging their customers to contact Congress and you know, put protections in place for online purchases. One large online retailer has a petition that customers can fill out, print, and, you know, send into their elected representatives. So it really depends if the business community can get together and speak in a rather single voice to lobby Congress to move something, to provide some type of standards across the various states. The other thing that would be an impetus for Congress to act is if we see a number of states go retroactive and cause a great problem for businesses, especially small businesses, that could be an impetus to get Congress to act as well. So I think it's a wait-and-see attitude, but you know, the dissenting opinion at the Supreme Court, written by Chief Justice Roberts, all four of them also thought Quill was bad law, but they didn't think the Supreme Court should overturn the prior precedent and it should be left to Congress. So really the Supreme Court's decision was a 9-0 decision that Quill was bad law and should be overturned. The split in the court was how it should be done. Should it be done by the Supreme Court, or should it be done by Congress? And we've seen some statements from some members of the Senate and the House, not too many, but a few of the more pro-business senators and congressmen have been, you know, calling on Congress to act. But I think we'll have to wait and see how far Congress will dive into the situation.
Oh, thanks. So along those same lines, too, we've seen states trying all kinds of methods to collect tax in the past, things like click-through nexus, cookie nexus, affiliate nexus, and we've also seen them separately put into place rules around marketplace facilitators. I wondered, Rick, if you could comment on, are those going to go away in favor of economic nexus? Do you see that continuing to, kind of play out?
Yeah, well, I think you need to put the nexus legislation into two buckets. So, I mean, there's been a lot of activity. About half the states have click-through nexus statutes in place, and a little bit more than half the states have affiliate nexus statutes in place. You just have a handful of states that have the cookie nexus, or looking at a computer cookie that the website puts on your computer from a vendor, and states saying that that software located on your computer in the state is enough to create nexus. I don't think those are going to go away. I don't think you're going to see a big effort to repeal those, but I think legislation activity that you're going to see in the future is going to be focused around economic nexus, or implementing a Wayfair type a bill. And again, New Jersey has one pending that was on the governor's desk, but there's some lobbying involved in New Jersey, and so that's being held right now pending some changes. And then the marketplace facilitator rules. So for those folks on the phone that don't know what marketplace facilitator rules are, is it basically transfers responsibility for sales tax collection from the actual legal vendor to a marketplace. So whether that's Amazon Marketplace or Etsy for arts and crafts, or whether that's Grubhub for picking up food from restaurants and delivering it to your home in the evening. There's about 200 different national marketplaces across the United States, and 2 states have statutory programs in place right now, Pennsylvania and Washington, that transfer the responsibility from the vendor to the marketplace to calculate sales tax and remit sales tax in a fiction that it was their sale, not the actual vendor's sale, but they're handling the cash transaction, the financial transaction. So those states think that the marketplace is the right place to do that, similar to the consignment shop rules that we've seen in a majority of states over the years. So there's actually a bill pending in New Jersey. There's a number of bills in New Jersey, so it's a good state to use as an example. But there's a marketplace bill pending in New Jersey, and there's marketplace bills pending in a number of other states. So those bills tend to upset the status quo and then look at the nexus of the marketplace as opposed to the nexus of the vendor to force sales tax collection. So I think those are the 2 types of legislation for those states that don't have it. Currently, I think we're going to see a lot more economic nexus threshold legislation for those states that don't currently have it, and obviously these marketplace facilitator rules that transfer responsibility to the marketplace. Because it makes it a lot easier for the states. They just have to audit the marketplace, not the thousands of vendors that might sell their little products through the marketplace. So I think that's where you're going to see the action from a state legislative perspective.
Thank you. Thank you. So I'm going to direct a question towards Nancy. So for those states that don't have economic nexus, kind of what timetable do we think we'll start to see them put regulations into place that line up with the Supreme Court, thresholds and whatnot?
Okay. So for those states who need to actually update their statutes in order to have some sort of economic nexus provision available to them, and keep in mind that some states may be able to do it through regulation, which might be a little bit easier or sooner, it might. But for the rest of them that actually need to pass legislation, we have to keep in mind that many of the state legislatures involved here are currently not in session. So it is going to take a little bit of time. In fact, we have heard from the state of Texas already saying that, they kind of intend to look at this and work it through the legislature, but of course their legislature doesn't reconvene until January. So so it really depends on the calendar of the state legislatures that are involved here. And Rick also mentioned the New Jersey statute. I think New Jersey probably could get theirs done faster than some of the others because they already had something sitting there waiting. So that kind of remains to be seen. So they'll come in over time.
Okay. Okay, thanks. So I'm going to quickly, so the polling question, we got results in, and the majority of you, for those who answered the question, felt you were somewhat prepared. Some were it was spread out, but the majority really said somewhat prepared. So you're not alone out there. Everyone's kind of looking at this and trying to figure out what we're going to do here. I'm going to move on and with a question around, we've been talking a lot about states. Maybe there's an assumption out there that, this is a problem for just U.S. companies. And I'm wondering, is this a problem for international companies as well? So I'm going to direct it first at Mike. Is there a legal basis for enforcement for international companies?
So there's so the answer here is obviously we're dealing with the sales tax realm, and I think what most of the folks on the call are probably used to is they're used to treaties or the concept of a PE, permanent establishment for income tax purposes. So since we're not kind of in that realm, what we're dealing with now is sales tax, which there are other legal bases for having foreign sellers or sellers outside the U.S. who sell into the U.S. and being required to collect and remit state sales tax. At this point, I would say that the states have the right to make those companies or sellers collect or remit to them, and so there's a couple of ideas around this. I'll mention a couple, and then I know Rick has a couple as well. But one thing, if you think about it, is that the main legal principle here is, can you force a foreign company into a state's legal system? In other words, force them into due process, and the answer is yes, you can, because even through a website, that's still considered enough to have a presence within that state and subject to the due process of the courts. So what they would do here then is they can get to them in various ways. One is, if they're selling a product, there are implied or explicit consumer liability products laws which they could seek to bring them in, even though it's a tax statute. Some of these foreign companies may have registered agents somewhere in the U.S. They could serve those individuals. They may use other kind of law or accounting professional services, and they would have a way to maybe also serve those individuals as well. So there's several things that are kind of outside of the tax realm where they can actually pull them in. Rick, I know there's some other ways to do it as well.
Yeah, Rick, do you have any comment on that?
Yes, with regard to inbound sellers that are selling into the U.S., one of the things that's confusing for the foreign companies is that permanent establishment principles really don't apply. That's why we're discussing Nexus. Nexus is the standard for state sales taxation. And international treaties are really based on income taxes, and mostly only federal income tax, not even state income taxes in many cases. So the treaties don't really come into to bear either. So the question is, if a state goes after the foreign seller, is there something for them to go after? So one thing the state could do is, if there's really nothing going on in the U.S. currently, and states generally don't go overseas to enforce judgments, is just put a tax lien on the company, put a lien on the books, and if the company engages in any type of M&A activity or financing transactions, those tax liens can pop up and cause problems. The other thing is, many foreign sellers, want to sell in the U.S. market and want to make it convenient to sell in the U.S. market. So they use U.S. banks to provide credit card processing services, and that means having a U.S. bank account. And if you have a bank account in the U.S., it's a little bit easier for states to attach or put a lien directly on that bank account if they're using a U.S. bank account, so that they can transact business in U.S. dollars. So, obviously it applies to foreign companies. The issue is enforcement, and there are a number of ways that states could enforce their powers on foreign sellers.
Okay, thanks. So I'm wondering, Rick, I'll direct this one at you. How prepared or knowledgeable do you think organizations internationally are in dealing with the fallout from this decision? Are they even aware? You know, companies from the smallest company to the largest e-commerce sellers in Europe, are they aware that this has even happened?
I think there's a general lack of awareness for overseas companies. I mean, I can only speak for what I've seen through Deloitte. Is we're trying to get the word out to our foreign firms, member firms around the world. Asia Pac and in Europe especially are big sellers into the U.S. So, you know, we're taking on an initiative to contact our clients and make sure the information gets out to our indirect tax professionals working in country in those countries and getting information out to them. But I do think there's a lack of awareness, and the problem is the reliance on the principle of PE, which is kind of a universal principle except for U.S. state taxes, is another problem where they don't think they have an issue. So getting the word out to them is definitely an issue and something that I know we are trying to do here at Deloitte.
Great. Great. That's when I've been at some international shows over the spring and talked to, you know, folks about e-commerce and about this decision. And I personally just found a lack of awareness that it was going on. So I want to move on to, so what are companies, you know, what are some of the operational and systems readiness considerations that organizations should be thinking about in order to be able to properly calculate, collect, and remit sales tax? And I'll start with you, Rick, because I think Deloitte has been having conversations, you know, sounds like globally, to help companies understand, you know, the nuances of this and help them understand how they should be planning, you know, both from an operational and systems readiness assessment.
Yeah, absolutely. Where we usually start is asking people to kind of review their situation. You know, do they sell into remote states where they're not currently filing? Have they taken no nexus positions in the past? And if so, they need to reevaluate that situation. And do they have a collection responsibility now based on volume of sales statutes or, you know, the old standbys, click-through nexus, affiliate nexus, agency nexus, things like that. Those still come into play in a lot of states. So they need to look at their situation, and then, you know, the client base generally breaks down into tangible personal property sellers of goods, and the sourcing of those types of transactions and the taxation of those types of goods is pretty straightforward. The more complicated one are obviously cloud services, software as a service, platform as a service, infrastructure as a service, and other digital goods and services, streaming services for entertainment, digital goods and services, music, movies, things like that, downloads of software. Those things are a little bit more difficult to source, especially in the business context with users in multiple locations. And then some states tax these types of digital goods and services and some states don't. So understanding the taxability of your product and that is it a retail sale or a wholesale transaction where your obligation would be to collect exemption certificates as opposed to collecting and remitting the tax is another thing that companies need to look at. So we are working with clients to look at their operational readiness. Do they understand the marketplace that they sell into and what their tax obligations might be? The other thing from a financial statement reporting perspective is obviously ASC 450, which is old FAS 5. You know, some of these states have said now that they're going retroactive. Some of these states came online July 1st, 2018. If you're not collecting the tax or did not collect the tax in those states but maybe should have collected the tax or started collecting the tax, do you have to book a reserve for this loss contingency that you may be facing for uncollected and unremitted sales taxes? So those are all types of issues that you have to think about. And then once you get past the tax theory, then you're into the tax systems. You know, do you have systems in place to deal with the calculation and collection of sales tax? So for that, I want to pass it back to Dave to talk about maybe some systems issues to think about.
Okay, let me jump in. So Vertex, as many of you know, actually provides tax automation solutions. We provide solutions at the calculation stage, so if you're an e-commerce player and you're quoting in a shopping cart or checking out in a shopping cart, we calculate tax in that specific instance. We also have compliance solutions that help you file your tax with the various states and local municipalities, and then we also included in that service, you can have remittance as well, where we'll do the payment for you. As Rick was saying, the sales tax rules, if a company has not had Nexus or had Nexus in a small number of states up till now, and then they need to have, provide calculation and compliance and remittance in 45 states that collect sales tax, there's a lot of rates and rule changes that will boggle your mind. Something like a Snickers bar versus a Twix bar, they're calculated, they have different tax rates and rules in different states. There's a lot of nuances, especially at the product taxability level, that it really behooves you to look at tax automation to kind of solve that calculation and compliance and remittance. A product like our product, we're one of several vendors that offers products that we keep track of all those tax rates and rule changes, and those are in our calculation engine, and then we will provide monthly updates to update all the rules. So we handle things like sales tax holidays, all the special product taxability, for all TPP and services as well. Across the U.S. at multiple levels, some states have returns that you're responsible for at the local level. So we actually have solutions that cover all the complexity. We offer solutions that are on-premise, hosted, and cloud that really allow you to pick and choose depending upon your needs, your IT needs, your policies internally. We serve businesses from the smallest companies in the world to some of the largest e-commerce players, on the planet, both in North America and international. So my advice is to really think about this. You kind of heard in this webcast that states are going to, do things at their own pace, but this is really a big decision to kind of think about. If you decide to automate, think carefully about what you automate with, because it really tends to be a long-term decision, one that's going to last multiple years. So you really want to do your research, think about it, but it'll take some time to get through that planning stage and also to get through, the implementation stage. So you probably want to start thinking about it now, even if the burden may not be coming for, a number of months.
Yeah, and I would add to that, if you're currently only filing sales tax in a few states and you're doing it in-house with a clerk-level type person, and now maybe you face having to file sales tax returns in 20, 30, 40 states, that's a big ramp up. So the question is, are you going to add clerks, or is it something you want to look about outsourcing or co-sourcing your sales tax compliance operations to just get the numbers from the compliance files onto a return and get them filed in a cost-effective way? So something to look at is in-house versus outsourcing.
Yep, okay. There was one more question. We're going to open it up to questions. So if you have questions, there's been some questions coming in along the way, and one Rick, that I might send your direction that has come in is, so you talked a little bit about, the taxation of services versus goods, and many people on the phone may be thinking more goods. Is there anything that you see more quickly happening on the service side? I know you mentioned some of the digital service taxability, and I don't know whether that is prevalent across the country, or in a smaller number of states, but I wonder if, if there'll be any implications for those services, the states that have services regulations.
Yeah, I mean, the issue is the states vary greatly. I mean, you have a state like California is almost a pure tangible personal property state. They tax a couple of services, but not many. And then you have everything, Hawaii, on the other hand, taxes everything unless it's specifically exempted. So, those two states are next to each other with the Pacific Ocean between them. But there are two extremes in the landscape. So, you know, there aren't a lot of states like Hawaii that start out with we tax everything unless it's specifically exempted, and there aren't a lot of states left like California that try and stay to be a pure, almost a pure tangible personal property state. So, I mean, the answer is it varies greatly from state to state. I mean, on the East Coast, you have New Jersey that does not tax cloud services, does not tax SaaS, and you have New York right across the Hudson River, and they do tax SaaS and cloud-type services. So, you know, the answer is not uniform across the country. If you're a provider of services, you need to do an analysis or use a tax engine like the Vertex tax engine to help with those decisions and making sure that what you sell service-wise is coded correctly or mapped correctly into the tax code for your particular service type so you get the correct answer out of a tax engine. If you're using some type of manual spreadsheet, then, you know, the research needs to be done on a state-by-state basis, but the issue is services are not uniformly addressed across the states. Even the streamlined sales tax states can turn on or turn off taxability of various services or digital goods, depending on if the state wants that in the tax base or not. So although the definitions are consistent from streamlined sales tax state to streamlined sales tax state participant, the tax base is not consistent, and you need to look at their taxability matrices and other information regarding the taxation of various service types.
This is Mike. I would just adding on to Rick's comment, the other thing I would add too is you also have to look at the sourcing rules around services. So sometimes states they'll source the taxation, the sales taxation of that service where the services are actually provided, and then other states can also source them to where the benefit of those services are derived. So, for example, if you have a situation where you might have architectural services, say, performed in one state, but yet you're building a building in another state, the question then sometimes becomes whether you collect the sales tax in where the services are performed by the architects or where the actual building goes up, where they derive the benefit of it. So that's something that you also have to keep in mind as well.
Yeah, sourcing is tricky, and then obviously some services, especially cloud services, can be consumed or used by a company in a number of locations. So it may be a multiple point of use issue where, just like software, it needs to be allocated between various locations in various states.
Okay, I'm gonna shift us over to another question. Thanks, guys, and I'm going to direct this at Mike. You know, talk about how the operational, you know, thresholding. How will it work? If you're selling in a state and you get to that $100,001, is the state going to look back and require you to, you know, collect and remit tax on that first $100,000 before you knew whether you're going to reach that threshold, or is it going to be really a look forward and require you, you know, to talk about how operationally that's actually going to happen in your opinion?
Yeah, I think what most states are going to do, and certainly was in South Dakota, is once you've kind of hit the thresholds, then moving forward, then you would collect and remit going forward. Obviously, it's hard to make, or impossible really, to make a determination whether you're going to hit the 100,000 level of sales or the 200 transactions in a state, you know, looking forward. So the state really kind of can't enforce that upon you. So I think here, Dave, what you just have to do is you just have to have a set of rules set up for whatever states that you're selling in, and be very aware of what those rules are. And then once you hit the thresholds, then you need to start complying. And I don't know if Nancy, if you had some other thoughts around that as well.
No, I think you covered that really well.
Okay, all right. I did want to add one other thing, Dave, just as it relates to what we've heard from some of our clients and customers as well. We have both middle market and large companies who actually have subsidiaries where they've sold, you know, in certain states, and they actually will have to turn on those subsidiaries for certain states where they've been remote sellers. So they're going to be doing some work around that. But But also to your question as well, Dave, more on the business side or the operational side, I think one thing that the folks on the phone call know, but I'm just going to remind you of it really briefly, is the calculation of sales tax is a key business component of your transaction. And I think, as you well know, if you don't get the sales tax right, your purchasers can short pay you, and then you're reworking an invoice that just will take a lot of effort that you probably shouldn't be spending time on. So I guess what I would encourage people to do is think about trying to really evaluate the states where you sell the most, get a solution around how you're going to handle that, try and be as proactive as you can in trying to hit the date that the states have. Obviously, once you've either missed an opportunity to collect the sales tax where you should have, then it becomes not just a customer sat issue, but it also becomes a cash flow issue, because if the tax is due and you're later audited, then obviously, and you haven't collected it, then the seller is going to have to pay that over. So I think there's just, and then the last thing I think that's important too is just from a business perspective. I think it's important that to the extent that you have a website or somehow you can articulate that sales tax collection is going to start becoming necessary in certain states, you really need to tell your customers about that so they're not surprised when they get a bill where they historically never paid sales tax and now they are doing that. So those are some of the things, I think, Dave, that we've seen with some of our customers recently.
Thanks, Mike.
Mm-hmm.
Well, a couple of questions came in, about Vertex solutions, so I can answer those real quickly. The first one was, is Vertex a tax engine that can be, integrated with various ERP systems? And the answer to that is yes. We actually have standard integrations to many ERP systems, to e-commerce systems, both e-commerce that are used in the U.S. and internationally. We have integrations to CRM systems and procurement systems. So you can, many of our customers want to use one tax engine with all of their systems. And Vertex is in a position to help you with that. Another question came in about our outsourcing, of returns. And we do have a returns outsourcing, piece of our business. So we've heard from some customers, well, the easiest way for me to comply very quickly would be to work with, a third party that could do the returns for us very quickly. And Vertex can do that for you. So it gets you up and running and kind of gets you in compliance, quickly, and then you can decide, longer term how you want to handle that.
Okay, so I've been also tracking some of the questions that have been coming across in the Q&A section, and Rick, I'm going to throw this one to you, and that is, it seems quite clear that the Supreme Court decision here is going to impact retailers, who are selling remotely, but how does the decision impact wholesalers and manufacturers? Can you talk about that a little bit?
Yeah, I think I touched on it earlier. I mean, I think it's an exemption certificate issue. Before, companies that didn't necessarily have a potential nexus obligation in another state didn't worry about collecting exemption certificates from people that they sold to on a wholesale basis. I think that the exemption certificate issue becomes a lot more prominent just to protect the company. I think that you're going to want to make sure that you have a robust solution for cataloging and tracking exemption certificates for customers that you sell to on a wholesale basis. And that way, if you're selected for audit, you don't really have any obligations if all your sales were really for wholesale, but some states may want to take a look at that. And so it's hard to get the exemption certificates later. It's much better to get them up front when you sign a contract or invoice for wholesale goods or services. So I would recommend taking a look at updating your exemption certificate process.
Yeah, and there are automated, ways to do that. Vertex, among other vendors, have automation for collecting, actually making it, putting the burden more in the hands of your customers to do the data entry and whatnot for exemption certificates. So we can help you on that if, you know, open to any conversations.
Yeah, I saw an interesting question that came in. It says, if we've self-assessed use tax on a purchase that did not have sales tax on the original invoice, what do we do if the vendor comes back and bills us sales tax on the same purchase? Will we have to pay and then apply for a refund from the state? I mean, normally what happens if a vendor is under audit is if you can provide proof that you accrued the use tax to your vendor, so some information about the use tax accrual and information about the return that use tax accrual ended up on, and you can supply that information to your vendor and show that the use tax was paid, that should get your vendor off the hook in their particular audit. So that's usually a process that would work to resolve that. And then one other quick question was that came in was, once you have registered in a state, do you need to file sales tax on a go-forward basis, even if your new year 2019 hasn't hit $100,000 yet, for example? And the answer is yes. Once you register for sales tax, you're a registered vendor, and the assumption is that you're going to continue to be registered and you're going to continue to collect tax. If for some reason that your sales are going to consistently fall below the threshold in the future, you would have to go through a tax withdrawal process with the Department of Revenue in the state. You just can't arbitrarily decide you're going to stop filing sales tax returns, because that will generate notices and problems. So if your business has a substantial change, that's a process that you could go through. But if you still have significant sales into the state, even if it's below the $100,000 level that got you in, you're going to have to continue to charge the sales tax on a go-forward basis.
Interesting. So there's one other question that came in around home rule states like Colorado. They have a very complex, as many people know, taxing regime for sales tax. And I wonder, Nancy, if you want to tackle how you see that changing, if it would change.
Oh, I was going to ask Rick that question, actually.
Oh, you were?
Yes.
Okay. Rick?
Well, yeah, I agree. Colorado is a tough state, right? Because if you think about the Wayfair decision, the case that was before the court was the South Dakota statute. So South Dakota is one of the states. They're one of the 22 states that are full participating member states of the Streamlined Sales Tax Project. So about half the sales tax states have adopted the model statute and adopted the definitions and procedures that are required by the model statute, which is central collection, central audit, same tax base for the state and the locals. Colorado is an example of a state that is nothing like that. Colorado is a state where the state has a tax, and many of the locals under the Constitution of the state of Colorado are home rule jurisdictions, and those jurisdictions have their own tax base that does not match the state tax base. They have their own filings. They have their own audits. So the big unanswered question from the Wayfair case is Colorado, state and cities, could Colorado state apply and cities not apply because they're too complex? We're just not sure, because Colorado doesn't really fit into the case, the Wayfair case, the same as South Dakota did. So are those barriers to entry for interstate commerce? Are those barriers to small businesses being able to be in Colorado and comply with both the state and the locals? So there are issues with a state like Colorado. They're clearly the poster child for this type of situation that could generate more litigation based on the Colorado state and local situation not being in any way similar to South Dakota's situation. But the Wayfair case doesn't address Colorado. That's not the case. That's not the case and the facts that were before the court. So again, the decision is very vast, but it doesn't answer a lot of questions, and that goes back to the issue of, should Congress step in and provide some bright line tests that would be across all the states regarding minimums, simplifications, filings, and audits? Wouldn't that be fairer to the business community if Congress did that? So Congress would be in the driver's seat on something like that, or the courts if a Colorado issue was litigated, but we're not going to know the answer to that for years to come if it's a litigation issue.
So there's a question here, Rick or Mike or Nancy. I'm not sure if you want to tackle this. It just came in about, for states with separate local filings, would it be recommended to wait until the state approaches you instead of going ahead to register? Any takers on that?
So,
well, I mean,
are they assuming? Yeah, go ahead, Rick. No, go ahead.
No, all right. I was going to say, you know, the problem is you need to understand how the locals are formulated. So, are the locals sovereign, or are the locals subdivisions of the state? So, in many cases, the municipalities or the towns are not really sovereign, independent entities. They're divisions of the state itself. So, you know, my view, I'm not saying it's Deloitte's view, but my theory, my view of this is that if you're in a state where the locals are sub-jurisdictions of the state, then once you have nexus in the state, you have nexus in all the locals. If you have a different situation where the locals are sovereign, then you have arguments about, you know, do I have nexus with a particular city? But I just think it's a tough case to win, to say you don't have nexus with a particular city when you have nexus with the state and the city is a subdivision of the state. So it's a tough tax theory issue that has not been well litigated, and so there's really not a lot of on-point guidance on this particular issue.
Yeah, this is Mike. I would tend to agree with Rick's view on that, and so I would think if you're a manager or and you're sitting there and you've got to make a call on this, then I would think you would probably want to just collect the entire series of taxes all the way from the state to the local level.
Okay, I'm trying to. So there was a question about, will the recording of the seminar be made available? Yes, it will be, along with the slide deck. There's also a question, we're starting to run short on time, about how we think this ruling, does it affect U.S. territories in Washington, D.C.? I'm not really familiar myself with the sales tax in those regimes.
Well, Washington, D.C. it absolutely affects. You know, some of the territories have a sales tax. Some of the territories don't have a sales tax. I think it goes back to the individual act in whatever territory that we're speaking about regarding what protections are in their statute and issues regarding nexus creating activities. But certainly the territories could look to this case as a standard for putting in their doing business or nexus requirements for a particular territorial sales tax.
So, Rick, another question came in. It's more specific than this, but I think the gist of it is that, you know, there's a number of transaction-based taxes that are not quote-unquote sales and use tax, but are kind of administered through that process. So how do we think that the Wayfair decision could impact those particular kinds of taxes?
Well, there has been litigation on other taxes that are not sales taxes. So an example would be the Ohio commercial activity tax, or another example would be a state E911 fee on telephone service. And so where courts have looked at these alternative taxes, for the most part, state courts have read and interpreted the Quill decision very narrowly and not applied the physical presence test in those types of cases. So the Ohio Supreme Court and the U.S. Supreme Court denied cert found that the economic nexus threshold for the Ohio commercial activity tax was completely constitutional, and that Quill didn't apply because it was not a sales tax. Likewise, the Oregon courts have found that the E911 fee, which is a collect and remit based on telephone lines, telephone customers based on each line or cell phone in the state, they found that Quill did not apply because that was not a sales tax. It was not a direct sales tax, so that the quill physical presence standard didn't apply. So from a litigation standpoint, we've seen the courts strictly limit the quill holding to sales taxes. So I think the Wayfair case, with it taking away quill, you know, the state's positions are strengthened that if you're doing business in a particular state, those other types of taxes or fees can apply to your business as long as you get over the due process threshold, which is pretty low, of actively soliciting or taking advantage or purposefully availing yourself of the economic enjoyment in a particular state by making sales into that state of a significant enough amount. I think that those other nuisance taxes and fees, license fees and things like that could be applied. I think Wayfair makes the situation worse for you.
Yeah.
That's what we think.
Yeah, yeah, thanks. Well, I'm going to answer one last question that's come in from a number of people. It's around where can we learn more about the state's timings and thresholds, and will Vertex be communicating that? We are working on, you know, that information in a central location that we will be communicating out on that. So that should be coming shortly. And I think I'm going to turn it back to Kathy to wrap up here.
Great. Thank you, Dave, Mike, Nancy, and Rick, for your wonderful insights today. We hope you enjoyed the webcast. This does conclude the webcast presentation today. If any questions we did not answer, we have collected them and we'll be following up via email. On behalf of our presenters and Vertex, I'd like to thank you for your participation today. Thank you and enjoy the rest of your day.